Welcome to this explainer. Today, we're tracing the complete life cycle of a UK legal agreement. We're going from the exact moment a contract is born straight through to how we decode its hidden rules, the anatomy of a breach, and finally, how the law actually steps in to cure it. If you're looking for a structured, foundational dive into UK contract law, well, you're in exactly the right place. Let's get to it. Here's our roadmap for today. First up, forming the contract. Second, decoding contract terms. Third, anatomy of a breach. And fourth, remedies and resolutions. Part 1, forming the contract. This is the birth phase, and the foundational rules we're looking at here apply universally across the entire UK. Now, to understand just how universal these rules really are, think about this. In English law, the exact same legal architecture applies whether you're just popping in to buy vegetables at a supermarket or closing a £1 million merger between multinational corporations. It's kind of crazy, right? The sheer universality of these rules means that one single foundational framework supports both our everyday transactions and massive commercial exchanges. So, how do we actually build this architecture? Well, it starts with two vital elements: offer and consideration. An offer is just a clear indication that one person is prepared to contract on specific, fixed terms. But here's the thing: an offer alone isn't enough. English law demands a true bargain, an exchange of value that we call consideration. It's essentially a promise given as the price for another promise. And no, natural love and affection absolutely do not count here. The law requires something with actual, recognizable economic value to make it enforceable. But even if you have an offer and consideration, you must actually intend for the agreement to be legally binding. And the law uses a pretty clever shortcut for this called rebuttable presumptions. Basically, if you make a deal with a family member around the dinner table, the law presumes you didn't mean to create a binding contract. But if you're in a commercial setting, that presumption flips entirely. The law assumes you absolutely intended to be bound, unless, of course, you explicitly state otherwise. Moving right along to part 2, decoding contract terms. Now that our contract is alive, we have to decipher its actual personality and the rules hidden inside it. You see, not all terms in a contract are created equal. The crucial point here is distinguishing between two main categories: conditions and warranties. A condition goes to the absolute root of the deal. Think of it like the engine actually working in a newly purchased car. Break that, and the innocent party can terminate the whole contract and sue. A warranty, on the other hand, is subsidiary. It's like the car being slightly the wrong shade of blue. Break that, and you only pay financial damages, but the core contract actually survives. So where do these terms actually come from? Well, beyond the explicit agreement you make or notices given before signing, terms can actually be legally implied into your contract behind the scenes. They can be incorporated through a regular and consistent course of dealing between two businesses over time. Crucially, the common law can also imply terms just to give a contract what's called business efficacy. And then you have statutes, like the Sale of Goods Act and the Consumer Rights Act 2015, which automatically imply strict protections into consumer contracts regarding quality and fitness for purpose. And this isn't just ancient legal theory, by the way. It actively affects how we live today. As our cities become denser and we live cheek by jowl in high-rises and shared spaces, traditional property models are really struggling. This housing intensification forces the law to rethink how rights and terms actually function in practice, particularly in property and tenancy agreements. It really shows how contract law has to constantly evolve right alongside modern society. As Baroness Hale famously outlined in Guys v. Société Générale, the courts imply terms for two distinct reasons. First, simply to make a specific business deal strictly workable, basically because the parties must have intended to include them. And second, because of the very nature of the relationship itself, like a landlord and a tenant. Even if the written lease is entirely silent on certain issues, the court will automatically step in and imply terms as a necessary incident to protect that specific dynamic. All right, part 3, anatomy of a breach. What actually happens when someone fails to hold up their end of the bargain? We'll start with the foundational academic definition from Tradle. A breach occurs when a party, without lawful excuse, fails or refuses to perform what is due from him under the contract or performs defectively. Those 3 words, without lawful excuse, are absolutely key here. For example, if a massive unforeseen event completely frustrates the contract, making it literally impossible to perform, both parties have a lawful excuse, meaning there is no breach. It's also really worth noting that liability doesn't always depend on fault. Many contractual duties are strict, meaning you can actually be in breach even if you tried your absolute best. Now, a major misconception is that a serious breach just erases the contract from history. It doesn't. Breach operates prospectively, meaning the contract is not set aside from the beginning. Instead, the primary obligations, the actual job you were hired to do, those die. But instantly, a new set of secondary obligations spring to life. These are the built-in rules that manage the legal fallout and the consequences of the breach. Surprisingly, the innocent party doesn't always have to terminate after a serious breach. They can actually choose to affirm the contract and keep it alive. But there is a catch. You must have a legitimate interest in continuing performance. You can't simply keep a dead contract on life support just to rack up a massive bill and maliciously punish the breaching party. The law demands a genuine, reasonable reason to keep things going. So, this brings us to a critical narrative crossroads. What happens when the contract is fundamentally broken, the primary obligations are dead, and the agreement simply cannot be saved? That leads us to Part 4, Remedies and Resolutions. This is the cure phase, where courts step in and attempt to make the innocent party whole again. The most common remedy is, of course, financial damages, which aim to compensate rather than punish. The main measure here is the expectation interest, which puts the claimant in the exact financial position they would have been in had the contract been fulfilled. And yes, this even covers lost profits. Alternatively, you have the reliance interest, which compensates for wasted expenses. But there are limits. Under the famous rule from Hadley v. Baxendale, you can't sue for unforeseeable, bizarre losses. Damages can only be recovered if they arise naturally from the breach itself, or if both parties could have reasonably anticipated them when signing the deal. To put that into perspective, if you needed a specialized part delivered just to keep your mill running, but you didn't tell the courier how important it was, you can't suddenly sue them for the entire factory's lost profits just because they were a day late. But what if a contract completely fails, never legally existed, or is voided entirely? That's where restitution steps in. While normal contract law enforces voluntary exchanges, restitution exists to prevent unjust enrichment. If you paid a massive deposit by mistake, or the foundational contract completely failed to materialize, restitution provides the safety net to pull that money back. It discharges unjustified benefits, ensuring fairness entirely outside the normal bounds of standard contract rules. Sometimes, though, money just isn't an adequate remedy. In these cases, the courts turn to equitable remedies which are granted at a judge's discretion. The major one here is specific performance. Now, this isn't just asking nicely, it is a powerful court order literally forcing the breaching party to do exactly what they promised. It's incredibly rare, reserved for entirely unique things like a specific plot of land or a one-of-a-kind antique where money simply cannot buy a replacement on the open market. The court can also issue injunctions to stop a party from doing something that actively breaches the agreement. We'll end our explainer today with a provocative question. When drafting contracts, parties often include clauses dictating exact penalties for a breach, but the Supreme Court maintains a strict rule against penalty clauses, refusing to enforce extravagant or unconscionable punishments. So does this judicial intervention threaten our fundamental freedom to make our own deals? Or is it a vital shield against exploitation when a bargain turns bitter? It's the ultimate balancing act of contract law. Thanks so much for joining me for this explainer, and I'll see you next time.